Hello, everyone, and welcome back to the Rebuttal podcast, where we break down case law, comedy, and of course, chaos that occurs in the legal field. I am, once again, your host, Reb Maisel, and today's episode, we are going to talk about this case. And here is the opener for you. Tearful testimony in $54 million pants lawsuit. A Washington, D.C. administrative law judge broke down in tears and had to take a break from his testimony because he became too emotional while questioning himself about his experience with a missing pair of pants. Administrative law judge Roy Pearson is acting as a plaintiff in this case. He is representing himself in civil court and claims that he is owed $54 million from a local dry cleaner who he says lost his pants, despite a sign in their store which ensures satisfaction guaranteed. The case gained national attention soon after the lawsuit was filed. I wonder why. Tomfoolery, perhaps? Probably the same reason the iconic court transcript series is so popular, right? We love to watch humanity burn and do diabolical things, do crazy things, do funny things, funny on purpose, funny without trying. This is so silly and ridiculous. And also the fact that the plaintiff isn't like a regular sovereign citizen going off the deep end, an administrative law judge. Active, not former, actively in the scene. Oh, yeah. The pants are expected to be introduced into evidence, although the judge says the pants are not his, and the correct pants are still missing. Now, some of you may have heard about this case already. Maybe you haven't. But usually, when you Google crazy fucking lawsuits, this one comes up. Why, you may ask? Well, because this article that I just read from, that opener, that cold open for you, is from 2007. Would you believe me if I told you that the pants lawsuit saga was not a few months or 1 year or couple year clusterfuck, as these often are? What if I told you that the most recent update was from 2020? In this episode, we are going to go through and touch on all of the main points, all of the pivotal moments that happened in those 16 years. If you are on your commute in the car, on the subway, buckle your pants and your seatbelt. This is the case of Pearson versus Chung. Pearson versus Chung, also known as the $54 million pants case, is a 2007 civil case decided in the Superior Court of the District of Columbia in which Roy Pearson, then an administrative law judge, sued his local dry cleaning establishment for $54 million in damages after the dry cleaners allegedly lost his pants. On May 3rd, 2005, Pearson delivered a pair of gray pants to a dry cleaning establishment in Washington, D.C. called Custom Cleaners to be altered. The establishment was owned collectively by Jin and Sue Chung, a married couple, and their son, Ki Chung, all of whom had immigrated from South Korea and did not speak fluent English. The pants that Pearson delivered belonged to a blue and maroon suit that he owned and were described by him as being gray with blue and red stripes on them. Pearson requested his pants to be ready for pickup 2 days later on May 5th, which Sue Chung, who took his order, agreed to. This sounds like the lead up to like some crazy situation or crime or slip and fall, or like I saw someone out wearing his pants and it ended up being a dry cleaning, laundering, embezzling, under the ground ring of like stealing people's clothes. Like that's what this sounds like, the run up to. It's literally not. It's I wish it were not as dumb, or maybe maybe I'm happy that it's dumb. So it's an episode. Either way. When Pearson returned on May 5th to pick up his pants, Sue Chung informed him that his pants were not ready and had been sent to another store they owned by mistake. Sue Chung promised to have them ready the following morning, but when Pearson returned on May 6th, the pants, quote, still had not been located. Sue Chung asked Pearson to return the following day. Pearson returned the next morning on May 7th, where the Chungs presented him with a pair of charcoal gray pants. Pearson insisted that the pants were not his, contrary to the dry cleaner's records, tags, and his receipt, and refused to accept them. Pearson demanded what he claimed to be the price of the pants as compensation, an amount of over $1,000, which the Chungs refused. What brand were these pants? I'm just super curious. And also, if anyone has ever met an administrative law judge or like a judge in general, like in regular life, I'm sorry to say, they don't have drip. Men who are administrative law judges, they dress their age, right? They're, even if they are, you know, in like more lucrative positions, if they're mediators or arbitrators and getting paid, you know, a decent amount of money to be doing, you know, private judging. Yeah, they're not wearing Gucci, YSL, Chanel to the function. They're just not. It doesn't matter how much they're getting paid. They might pull up in a Ferrari. They might pull up in an Aston Martin. But like the drip itself is not giving $1,000 pants. I'll tell you that. Lawyers out there, if you want to prove me wrong, or maybe criminals, not criminals, defendants, former defendants or current. If you have seen your judge outside the robe in a fine pair of $1,000 pants, please comment below. Would love to be proven wrong here. As a result, Pearson filed suit in the District of Columbia's Superior Court. The judge to whom the case was presented decided to bring it to trial on the basis of two of Pearson's claims. The first claim was the issue of ownership by Pearson of the presented pair of pants. The second claim was on the issue of signs posted outside the business, advertising same-day service and satisfaction guaranteed, which Pearson claimed to be misleading. Now, let's pause here, okay? Because those are actually valid claims. Like, if they are genuinely a $1,000 pair of pants and they're presenting pants that weren't yours, blah, 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 it's the same thing as being, something was stolen, a valet crashing your car and it resulting in $1,000 worth of damage. You should be compensated to sue to get your fucking pants back, especially because you're pissed, or to sue to get what they're worth back, right? But like what he sued for was decidedly none of those things, which is why this has its own Wikipedia page. The Chungs were reportedly considering moving back to South Korea. After an outpouring of support for the Chungs from members of the public, a website was set up to accept donations for the Chungs' legal defense. Over time, the Chungs presented 3 settlement offers in the amounts of $3,000, $4,600, and $12,000, all of which were rejected by Pearson. D.C. Superior Court Judge Neil Kravitz stated that, quote, "The court has significant concerns that the plaintiff is acting in bad faith." The judge resolved some of these issues in the Chung's favor in response to their motion for summary judgment, which was filed at the close of discovery, but could not dismiss the case because some facts were in dispute. On May 30th, 2007, Pearson reduced his demands to $54 million in damages rather than $67 million. Among his requests were $500,000 in attorney's fees, $2 million for discomfort, inconvenience, and mental distress, and $15,000, which he claimed would be the cost to rent a car every weekend to drive to another dry cleaning service. The remaining $51.5 million would be used to help similarly dissatisfied DC consumers sue businesses. Pearson is a judge. Just going to remind you, just like real quick. Just going to keep that in your head. Pearson also refocused his lawsuit from the missing pants to the removal of window signs for satisfaction guaranteed and same-day service. Pearson claimed the signs represented fraud on the part of the Chungs. The Chung's lawyer, Christopher Manning, alleged that the signs could only be considered fraud if a reasonable person would be misled by them, and that a reasonable person would not see the signs as an unconditional promise. The Chung's lawyer portrayed Pearson as a bitter, financially insolvent man. Under questioning, Pearson admitted that, at the start of the court case, he had only $1,000 to $2,000 in the bank due to divorce proceedings and was collecting unemployment benefits. There we go. There's your sign. Thank you for that. Thank you for that little tidbit. Because at first I thought it was just insanity. It is still insane, but I mean, desperate times, desperate measures, right, my guy? Good Lord. The trial heard opening arguments. Yes, it still went to trial. He did not accept settlement. The trial heard opening arguments on June 12, 2007, with Pearson representing himself pro se. Are we shocked? And the Chungs being represented by attorney Chris Manning. The trial drew a standing room only crowd. Everyone pulled up. They said, you know what? I'm actually going to call out sick today. And I would too. Pearson broke down in tears during an explanation about his frustration after losing his pants, and a short recess had to be declared. Did he break down in tears about the $1,000 pants, losing them? Or was maybe he implying losing his wife in the divorce? Maybe losing his money in the divorce? Maybe losing other things in your life? Maybe some things are just metaphors, Pearson. My pal, my guy, my fellow lawyer, my colleague. Maybe we don't have to project onto everyone and everything. Or maybe you loved those pants. Let me see them, actually. They better have made your ass look damn good. I'm sick. On June 25th, 2007, after a 2-week trial. 2 weeks! The trial ended with District of Columbia Superior Court Judge Judith Bartnoff ruling in favor of the dry cleaners and awarding them court costs pursuant to a motion which the Chungs later withdrew. The court took judicial notice of Pearson's divorce proceedings, where he was sanctioned $12,000 by the trial court for, quote, creating unnecessary litigation and threatening both his wife and her lawyer with disbarment. Oh, Pearson, it keeps going. We're still in 2007. Pearson made a motion on July 11, 2007 to reconsider in the trial court, stating that he felt the judge had, quote, committed a fundamental legal error and had failed to address his legal claims. Pearson stated he believed the court had imposed its own conditional interpretation of, quote, satisfaction guaranteed, rather than what Pearson believes is an offer of unconditional and unambiguous satisfaction. The court denied the motion. It was revealed on August 2nd, 2007, that a panel recommended Pearson not be given a 10-year term as an administrative law judge after his initial 2-year term expired mid-2007. To have filed this lawsuit in the middle of being re-upped for your job, it's not just like, oh, a promotion. Literally, you're up for fucking tenure, dude. Like, you are balancing on a wire-thin hair here. You could have just sat there and ate your food and kept your head down and issued not totally shitty rulings as an administrative law judge and gotten that 10-year contract, baby. Woo, employed. You mentioned previously, I couldn't help but notice, that you're broke. That you're broke because your wife is taking you for everything you have. You are broke. You need a job. And administrative law judge, yeah, it's not like the highest paying fucking job in the world, but it's a job and it's a reputable job. And fuck, like put that shit on your resume, you know? You could do maybe like you could be a mediator, arbitrator, a mitigator, literally a mitigator, and like so many things. But a few months before you were going to be re-upped for 10 years, you said, let me do something crazy. I'm not going to ask for money from a job. I'm going to ask for money from my dry cleaner. Right. Here's some advice. I think you should take 2 weeks off, then quit. Because you should not be in that seat in any scenario. If this is what you're legitimately pursuing, you have to hold up some level of decorum when it comes to litigation in the court, even if it's not your own, if you want to be a judge. So yeah, he literally snatched defeat from the jaws of victory with respect to his 10-year term being re-upped. Oh well, you get a 2-year term. And now a panel is recommending that you don't get the 10. Stunning finale, stunning finish, my guy. But we're not. That panel recommended he not be given a 10-year term after his 2-year term was up to expire, in part because his lawsuit against Mr. Chung demonstrated a lack of, quote, judicial temperament. Pearson was appointed in 2005 and stood to lose his $1,512 yearly salary if a hearing upheld that decision. My king, you're going to be way broker. Come on. On October 22nd, a D.C. commission voted against reappointing Pearson to the bench of the Office of Administrative Hearings. On November 14th, it was confirmed that Pearson had lost his job by not being affirmed for an extension. So what does Roy Pearson do? What any rational person would do. He filed suit against Washington, D.C. on May 2nd, 2008. Claiming he was wrongfully terminated for exposing corruption within the Office of Administrative Hearings. Pearson sought $1 million in compensation for lost wages and punitive damages, as well as his job back. On July 23, 2009, Federal District Judge Ellen Segal-Huvel dismissed Pearson's May 2008 lawsuit, ruling the District of Columbia had not broken the law by declining to reappoint him as an administrative law judge. Pearson had maintained in the suit that the failure to reappoint him to the 10-year term was in part intended as retaliation for his suit against the dry cleaners. Pearson lost his appeal when the D.C. Circuit ruled against him on May 27, 2010. The Chungs over here, okay, we got multiple litigations going. All right, we have a lot of cooks in the kitchen. Well, no, we have one cook in the kitchen stirring a lot of pots, and all the pots are bubbling over on him. Great analogy, Reb. Thank you so much. The Chungs moved to recover $83,000 in attorney's fees and to impose sanctions, but withdrew the motion after recovering their costs through fundraising. They just wanted to not have to deal with this anymore. Roy Pearson is damn lucky that these aren't pettier people. And to use your position of power too as an administrative law judge, I can't even imagine how he was like as a customer, like before he filed this lawsuit, but also during this. Like he was the one having to do these negotiations and all these settlement discussions. I'm sure he was just such a fucking asshole to them, like acting like, oh, they don't know anything, they're fucking stupid. Oh my God. The Chung stated that they withdrew their motions to recover their costs in the hopes of persuading Pearson to stop litigating. But on August 14th, 2007, Pearson filed a notice of appeal. So Pearson was not persuaded. He is not stopping. He is throwing down another pan in addition to the stirring pots, putting some bacon directly on some already heated grease so that it could fly up and pop right on his bald head. And that's exactly what it did. On September 10, 2008, Pearson filed an appeal to the District of Columbia Court of Appeals, where oral argument was held on October 22, 2008, before a 3-judge panel consisting of judges Phyllis Thompson, Noel Anketel Kramer, and Michael W. Farrell. Now, mind you, typically when you do appeal to the Court of Appeals, DC Court of Appeals, and most Court of Appeals, not all 9 of the judges on like the DC Court of Appeals panel is going to rule on your case. It's usually 3, okay? Like 3, like a batch of 3. when you file an appeal to have something heard en banc, like if you're like, no, like they wrongly decided this, it's after that 3-judge panel goes through, right? And they like render a decision. This has happened before. And then they're like, wait, we're going to rehear this en banc, meaning everybody pull up. All right. All the judges pull up, and then it's like a different decision, or all the judges pull up and go, we're staying with our gang. Got it? Again, simplest way I can explain it. Do not tell this to your civil procedure law professors, and then I'll get strongly worded emails about how, well, actually, and it'll be like a 40-paragraph thing that nobody would want to hear me read on a podcast. So that is the gist of it. Anyways, Manning represented the Chungs on the appeal pro bono. That's nice of him. And Pearson represented himself pro se. Are we shocked? On December 18th, 2008, the panel that heard Pearson's appeal announced that they were rejecting it. Pearson has 2 remaining avenues of appeal left. He could ask the entire 9-judge appellate court to review the case. Yep. What's that called? En banc. You got it. Now you know. Or ask the Supreme Court, the U.S. Supreme Court, to weigh in. Those are his options. On January 6, 2009, Pearson filed a petition with the D.C. Court of Appeals requesting the case to be reheard en banc by the full 9-judge court. Because of course he did. On March 2nd, 2009, the appeals court denied the petition. Pearson's final option was to ask the U.S. Supreme Court to hear the case. The 90-day deadline, however, shockingly, this is the only time I've gasped since I've, gotten to know Roy, our boy Roy, this man. The 90-day deadline for seeking Supreme Court review elapsed without Pearson filing a petition for writ of certiorari. So that brought this dispute to an end, you would think. But Pearson wasn't done, because after losing the dry cleaner's suit over his pants, Pantsgate, the American pants saga, the $65 million pants, after losing that case and then also losing his wrongful termination lawsuit and then appealing it and then losing again, it turns out that if you persist in making the same frivolous arguments for a sufficient number of years, the Bar Association that you're a member of as a lawyer and a judge will take notice. In 2015, the DC Office of Disciplinary Counsel filed ethics charges against Pearson, which of course he furiously contested on the grounds that he had been right all along. He lost, and of course he appealed. This is now what, 2015? It was 8 years after he initially filed suit? Correct. On June 4th, 2020, 15 years after his pants allegedly vanished, Roy Pearson lost again. The D.C. Court of Appeals agreed that Pearson had violated the rules of professional conduct. So the rules that strictly govern attorneys and judges, okay? Those rules were 3.1, which is the rule against making frivolous arguments, and 8.4D, which is the rule against lawyers and judges interfering with the administration of justice. Now, making a weak or aggressive legal argument once or twice is not going to get you in trouble. Obviously, but probably, but maybe, but usually not. But as Pearson's lawsuit went on, the court explained, quote, his liability and damages arguments morphed into the preposterous. Not only did he demand well over $60 million in a dry cleaning dispute, portions of that total demand were themselves independently stupid. For example, he sought $3 million in emotional distress in a lost pants case and demanded a judgment that would require the owners to pay him $10,000 in the future whenever he felt, quote, unsatisfied. I can only imagine that women who've had terrible ex-boyfriends could only dream of suing for damages like this. There have been juries that have not valued a human life as much as $3 million, or at least someone's relationship to that past human life. But pants, they must have been a great pair. They must have been a great pair of slacks. Why is no one mentioning the fucking brand of pants in any of these filings? Like, hello, I want to know the brand. If anyone finds out the brand, let me know. Go on the hunt. Love you so much. Drop it in the comments. I would like to know. The subjective, quote, satisfaction guaranteed argument was also nonsense to begin with, the DC court noted. In short, no reasonable attorney could have concluded that this case had even a faint hope of success on the legal merits. I agree. As for interfering with the administration of justice, one way to do that is to persist in aggressively litigating a stupid case for years on end. You don't say. This case should have been in small claims court, if brought at all, which some of you may have already been yelling at me about and probably commenting in the comment sections about. I'm aware, okay, but I knew I was going to get to this part. This is why small claims court exists. Like, literally, why? Why the fuck is the DC Court of Appeal hearing this fucking case? Like, what the fuck? Like, small claims court, keep it cute. Okay, keep it cute. Y'all can yell over $1,000 all the time. Businesses will fuck your shit up. Businesses will take things from you. I mean, landscapers will fuck up your lawn, kill your grass, resulting in damages. I don't care if it's $20 or $50. Like, you are absolutely entitled for your money back, for a refund. That's why the Better Business Bureau, like, you know what I mean? Like, all those things. Like, I get it. I'm not saying that people shouldn't get recovery, but that's the way to do it. That's why we have those things. Why we already have so many avenues that you can go to, the third-party avenues, if you know, the owner of the business is like, fuck y'all, we have so many regulations, you know what I mean? Like businesses, customer satisfaction, all right? Consumer protection laws, all right, in place, and agencies that handle this. Why? So that the courts aren't fucking tied up with this bullshit. Over $1,000 fucking dollars. But because he asked for 54 mil, like that's why. Because he was claiming all this random shit. But ultimately, it was literally over a fucking pair of pants. So, like, you should have been in small claims court. If you would have been in small claims court, you would have gotten $1,000. That's for sure. Whatever. Or any of the settlement offers that they gave you to just stop bothering them. The settlement offers were up to $12,000. I can't. I'm poor and made a divorce. You were getting paid a salary per year that you literally threw away because you get it. So the court pointed out that that case should have been in small claims court, if at fucking all. And by filing it in the superior court, flooding his opponents with discovery demands and repeatedly making the same bogus arguments, Pearson was essentially wasting everybody's time, including the courts. Absolutely. It probably didn't help that Pearson, who represented himself, has continued to blame everybody but himself for the disaster and to toss a few insults into his briefing for good measure. He called the disciplinary counsel's arguments, quote, crude and inept. Oh, pot meat kettle. Accused the hearing committee of being racist, and called the D.C. Court of Appeals decision on the merits of his pants case moronic. That would be the same D.C. Court of Appeals reviewing the sanctions order against him, which further suggests Pearson has not gained much wisdom over the course of this saga. The result? A 90-day suspension, which seems pretty lenient for such aggressively bogus conduct spanning multiple cases, and so far 16 years, because the pants were initially lost in 2004. Since 2020, there have not been updates on this case. So presumably, he took the 90-day suspension, and it was up. He didn't appeal with the U.S. Supreme Court or the International Court of Justice, which is not necessarily an avenue, but I could definitely guess that this guy would literally try anything and everything. Pearson still retains his DC bar membership. What is even more sad is that the Chungs really suffered egregiously from this. On July 24, 2007, the American Tort Reform Association and the Institute for Legal Reform of the United States Chamber of Commerce hosted a fundraiser for the Chungs to help pay their attorney's fees that reported having raised up to $64,000. So, like, the American Tort Reform Association basically is very much on the forefront of being like, look, like, we understand that tort laws are important and people should be able to sue, but like, we should definitely go after the offenders of egregious misuses of the system. The Chung said they had received close to $100,000 from supporters to cover their attorney's fees and lost business. On September 19th, 2007, however, citing a loss of revenue and emotional strain from the lawsuit, the Chungs announced that they had closed and sold the dry cleaning shop involved in the dispute. They still owned another dry cleaning shop, however, and said they would be focusing their attention and resources on that. Good for them. If you live in the DC area and have any intel about whether that loan store is still operating, let me know. I've tried to look it up. There is a custom cleaners listing in DC, but I don't want to confirm that it's them. If it indeed isn't. So if any of you want to let me know if you have any personal anecdotes, please do not walk into custom cleaners and say, hey, are you the people involved in the lawsuit? That is rude and uncouth, and we don't support that. My rebuttal for today's episode is to keep it cute and couth, because Roy Pearson was not either of those things. And that lost him a job, his wife, his money, and all of our respect for him. But he's still a lawyer. Jokes on jokes today. Have a great rest of your day and week. I love you. We'll see you next time. Hope you enjoyed this little episode. Stay safe. Love you.